GM. May I have the confirmation that we have all of our same parties again, please?
Alexis Spencer, attorney for petitioner Amber Million.
Counsel for petitioner Amber Million. Okay, thank you.
Sean Hennepin on behalf of respondent Gail Warner.
Rebecca Haynes also appearing on behalf of respondent.
Very good. I think we have all other interested parties. I see them here. Thank you for joining us. And we have Mr. Warner, courtesy of Wyoming County Jail.
Warner, Ariel Berger here on behalf of P. Warner.
Yes.
Suzanne Will Hill on behalf of AW.
Good. You're up already, Mr. Head.
I don't know if Your Honor would like to consider my continuation of what I started earlier, or if we'd like to hear that at a later time.
So I have some comments to make before we get started today, Mr. Head. So why don't you have a seat? We are going to proceed with, for purposes of today's hearing on the guardianship itself. The statutes and court rules prefer that we have an answer on the guardianship within 28 days of the filing of the petition. It allows certainly for modification and request for termination as that may arise and be appropriate. So we will be, I would like to make that decision on the guardianship this morning if possible. I know from the brief discussion I had with co-counsel this morning, or all of our attorneys, that one of the issues that is going to be continued to that you're going to be asking me to rule on is whether or not we have a suitable guardian, or if the initial petitioner, it would be a better guardian. And so I will listen to some of that testimony today, but I think that I will remind parties that there is a preference for the preference of the child and the preference of the parent on that case, on that piece, and the suitability of that preferred guardian would be effectively the barrier on changing from the preferred guardian, which I know we didn't have a ton of testimony on that point last time, but we did certainly have enough testimony for me to make an initial ruling, and it was persuasive. So I will just signal that to all of you as you make your way through your proceedings this morning. So that being said, let's begin with our petitioner.
Your Honor.
Any comments?
Yes, Your Honor. May it please the court. While I understand that there's a preference as to the parents and a child's suitability or guardian request, I believe that in looking at the best interest factors in this case, that the best interest factors will demonstrate that Amber Million is the more suitable guardian for AW, and that it would be in her best interest that Amber Million be appointed as her guardian. Thank you.
Any other open comments other than what we've heard so far?
Just that, as the court already indicated, Mr. Jaron Warner has been appointed temporary guardian. He was not found to be unsuitable, certainly found to be suitable for the temporary guardianship purposes. There's been no evidence that he's unsuitable. In fact, I've heard sister counsel and others mention how good of a person Jaron is, and now how there's absolutely nothing that's been bad ever said about him that I've ever heard. So with that being the court's barrier, as the court used, as to the unfitness of Jaron Warner in order to change the guardianship from him to some other individual, I don't believe that would be appropriate. And if there will be any evidence presented as to Jaron's suitability, I think that these proceedings should be limited for that purpose, to meet that barrier or to overcome that barrier, as Your Honor was indicating earlier. Additionally, I think we should hear from the GAL before we hear from any testimony or the court-appointed attorney for AW. Additionally, I think the court needs to remember or be mindful of the fact that there's been a lot of publicity surrounding Dale Warner, obviously. AW is susceptible to that. She hears that, she sees it. She sees the social media posts making disparaging comments about her father. That is damaging to her. Those posts are not coming from Jaron Warner. Those types of comments are not coming from Jaron Warner. Those types of comments are coming from D. Warner's children, including the petitioner in this case, by making likes and comments on social media posts that Angelina can hear about at school, that Angelina can hear about from that AW can hear about from her friends, that she can hear about from other members of the community. And that, I think, should go to a suitability determination as well, or an unsuitability determination as well. Because making disparaging comments about somebody who's innocent until proven guilty is certainly damaging to AW and her future and her current condition. Additionally, Jaron Warner, as a temporary guardian, has made arrangements to have a trauma therapist counsel AW. The first appointment with that specific trauma therapist is scheduled for this upcoming Monday. There have been some delays, and he was they were on a waiting list. One individual that they did meet with, who was a trauma therapist, actually denied to see her and did not believe that she was qualified for such a large type of a situation. But there has been another specialist that has been scheduled for Monday, like I said. Additionally, AW is seeking regular and participating in regular counseling. That should not be disturbed. She's living in her home. Jaron is living with them in their home. That should not be disturbed. She should not be forced to, with everything else that she's going through, she should not be forced to vacate her home, get away from her bedroom, get away from the people that she's been with for the last 2 years, during all this turmoil and during all these traumatic events. None of that should be disturbed. I believe that we're going to hear from AW's attorney that's going to reiterate some of these facts, and also reiterate how, despite everything that she's going through, her condition seems to be improving over the last few weeks, which is great to hear. And that factored with the fact that she's continuing counseling, the fact that she's going to participate in additional trauma specialized counseling, none of that should be disturbed. The status quo as it is right now, with Jaron Warner serving as AW's guardian, should remain the same. Simply put, AW has been through so much, it would not be in her best interest under any legitimate objective standard to change that now. It just doesn't make sense. It would not be good for her. So I'd ask that the court hear from her attorney.
Thank you. All right, Ms. Berger, did you have anything that you'd like to say by way of opening?
No, Your Honor, I'll wait a little bit.
Okay, and Ms. Wilhelm? All
Yes,
right.
Your Honor.
Deputy Ames, I will ask, would you like to move to the podium, or would you like us to bring you the mic?
I'll take mine. Mine still gonna follow the floor yet again. Thank you. Yes, Your Honor, on behalf of Angelina Warner, I would like to say, and we'll let the court know what it is that she wishes. And I'll let everyone know that right now. Everyone knows what she wishes. Jaron Warner and I spoke about it. I let him know, so everyone knows. Angelina Warner would like to stay in her home. She would like for Jaron Warner to continue to be her temporary guardian. And she does we didn't talk about what temporary meant. She knows the word, but she would like for him to remain the person who takes care of her and takes her to school and takes her to gymnastics and does all the things that he does do for her as temporary guardian. She definitely wants that. She's not on the fence about whether she wants to leave her home or whether she wants to, to move over and be with Miss Million. No, that said, what she also wants is more visitation with Miss Million. She specifically has asked on countless occasions now to see her nephews. That has been a source of contention. And but she wants that. She wants to see them. She wants to see Raquel and the new baby next. So this girl knows what she wants. She orders it up. She's extremely intelligent. She's blossoming. Your Honor, I do, at the appropriate time, I do have an exhibit from the principal at her school, who spontaneously told me when I called to just check up on her, that no, all of a sudden she is like better. She is taking a tremendous turnabout. He said, I didn't even have to ask her to speak up. She's raised her voice, she's talking. And then he just told me yesterday that just yesterday, walking to chapel in the groups, how they walk, she was with her friend group, and it was her voice he heard. So she is responding very well. Ms. Moore is surprised at how well she's responding and has, moved visitations and asked visitations be twice weekly. I'll say more later. I just want the court to be aware, as the court decides about going forward here, that she does not need to be interrupted in this, nor does she need to be interrupted in her rebonding with her family, with her other family. She wants to see them, and she makes no bones about it. She is not on the fence about that. And she wants to go to community events. She wants to go. I specifically asked her, would you want to go bowling with your sister? Amber, she said, yes. I said, would you want to go? How about movies? She said, yes. I said, well, how about nail salons? She said, yes. I said, well, because these are the things that they would do naturally together. And she said, yes. And she wants Amber and the boys, for that use, to attend her band concert tonight. So, I mean, these are things she's not on the fence about that, but she's not on the fence either about wanting to stay in her home and wanting her brother, Jaron Warner, to continue to be her guardian. She's not on the fence about that either. With that, I will reserve the rest of my comments until the court orders a continuation or we have those. Thank you.
Thank you. Do you want to, one moment, please. Do you want to address any exhibits today before we get started?
Your Honor, I have a exhibit and it's from Renee regarding the assessment of AW as well as the visit log. So I would like to submit that. I know that we have provided that to all counsel.
Any objections?
No objection.
Thank you. I'll take that as petitioner's exhibit 1.
Your Honor, briefly,
Yes?
Mr. Jaron Warner is not formally represented by counsel. I would just ask that he be given the same opportunity as the attorneys in the courtroom. So if he would like to make an opening statement or anything to that effect, I would just ask that he be afforded that opportunity.
Any objections?
No, we would agree. We were going to ask for the same thing. And I believe he does want to speak. So.
Yes, I saw your hand.
No objections.
No objection. All right, come on up to our podium and give us your full name.
Hi, Your Honor. I'm Jaron Warner. I'm her Angelina's temporary guardian.
Yes,
We almost will witness.
I'll let you know. Would you swear in Mr.
Raise your
Williams?
right hand, please, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, the record should also reflect that I received 2 copies of the exhibit 1. So I guess if you need an extra, I've got one, but I look forward to your comments. Go ahead.
I just wanted to comment that I think that we should listen to what Angelina's opinion is and take that with the strongest consideration. I'm not opposed to visitations. I do see that she says that they're going okay, so it makes me feel better about it. I do kind of question that twice a week. She's got a busy schedule as it is. If they want longer durations for maybe one visit, that'd be preferable, I guess. But I think, like she said, she's gone through enough and we don't need to put any more trauma on her. I think she's kind of current state how she is. She's doing well, so keep it status quo. Thank you.
Thank you. Okay, so. Ms. Kuhn, I would like to hear your position as it relates to the request made by Mr. Head to limit the conversation or the proceedings, I should say, to the issue of whether or not our limited guardian is suitable.
Your Honor, I think that there are I think we need to consider the best interest factors, Your Honor, so I don't want to limit it to suitability.
Right, well, I will let you go into that, and then, I'm sure Mr. Head will let us know if he thinks that we've gone into an area that, perhaps is a bit afield of what could be considered relevant for purposes of today. So who would you like us to hear from?
Your Honor, I would like to call Detective Sergeant Dan Drewer as a witness.
Is he here?
He is, he's out.
I'd ask for an offer of proof. Prior to that, what would he be testifying to that affects AW? And the suitability of the proposed petitioner and Mr. Jaron Warren.
Your Honor, the detective sergeant has been the lead investigator in the investigation involving Dale Warner. He also interviewed AW, and he has also, because he's been the lead investigator, has during the course of his investigation has learned a lot about what had occurred in the home. So I believe that his testimony would be very relevant to best interest factors in the home, as well as the relationship that Amber had with AW and Amber's family prior to when Mr. Warner cut ties off with the family. I believe also that there may be some testimony as to what Jaron's relationship was with AW prior to Dee's homicide. I am not going to be asking him anything pertaining to the current charges that are before Judge Schaefer. So I'm only going to be discussing and requesting testimony from the detective regarding those factors that relate clearly to the best interest factors.
Yes.
Thank you, Your Honor. What I hear, first of all, alleged homicide. He is, Dale Warner is innocent until proven guilty. There has been no adjudication on that issue. We object to any use of the term homicide or any implication that he's committed any crime. Aside from that, what I heard Sister Counsel offer is an offer of proof of multiple sources of hearsay, multiple instances of hearsay. Detective Sergeant Drewer would not have any personal knowledge as to any interactions within the home. All that he could possibly testify to is what other people told him. And that cannot be offered for the truth of the matter asserted. That is certainly hearsay and should be precluded by the court. To the extent that he had any personal knowledge, I think his testimony should be limited to that alone. But I don't think that he could have any personal knowledge. He's never been in the home. He's never resided with either petitioner or Mr. Jaron Warner. He would not have any ability to offer any testimony that would be relevant or not hearsay as to the suitability of Jaron Warner. So I don't think that it's necessary. I think it does nothing but confuse the issues and burden the court with unnecessary testimony that would likely be precluded because of hearsay and other reasons anyway.
Who else would like to be heard on this?
Yes, morning, Your Honor, thank you. Detective Drewer has personally interviewed AW. He's personally observed an interview done with AW, and because of that, he does have substantial personal knowledge related to her and to her family and to her connections with her siblings. There's no other individual probably in the world that has more knowledge regarding this child and his family than Detective Drewer. I still have a client. I'm still here, which means my client has not been declared dead yet, which means she does have a say and she does have an opinion. And I believe that if she were here, she would want him to testify because he has the most knowledge. In addition, Your Honor, pursuant to Court Rule 5.404, the court does have a duty to take into consideration all relevant evidence in a guardianship case related to a minor. And that does include written reports, it includes testimony, any other evidence that can be relied upon to go to the best interest factors related to the child under MCL 700.5101. So at this point, Judge, we do believe that it's necessary for him to, for Detective Dreyer to testify. I will agree that his testimony will be very limited to his personal knowledge and the knowledge that he's gained through his investigation. And I'm sure that if there are hearsay issues, Mr. Head will be able to object. And if we have the applicable statute to overcome the same, then we will produce it. But again, Judge, in this type of setting, because we're under a minor guardianship hearing, there is a lot of evidence that is admissible, even if there is hearsay. Rules of evidence apply differently in a probate court, and we would just ask that that be taken into consideration when determining if this witness is able to testify. Thank you.
Ms. Wilhelm, did you want to share anything?
Yes, I would, Your Honor. I would just want to know what dates it was that that the Detective Dwyer did meet personally with Angela Warner. I'd just like to know that age. If I may.
I'm sure he will tell us.
Yeah, we can hear it from him too, then, but.
Mr. Head,
Yes, a couple things. I think in considering whether the court would even hear such testimony, not only are the dates important, because obviously this investigation's been going on for 2.5 years, but the purpose of any interviews that Detective Sergeant Dreyer would have had with AW is certainly not what's in her best interest. His purpose was to investigate a crime or investigate a disappearance. And very quickly, I believe when he got involved, he was investigating a crime. I believe he's testified in prior proceedings that his only suspect was Dale Warner. So he was specifically, his purpose was not to determine what was in AW's best interest, not to determine some objective conclusions as to who should be suitable to care for her or whether she's being adequately cared for. Instead, what his purpose was to investigate what he believed was a suspect for a crime at that time, who happened to be her father. So he was not seeking any objective information. And so that any interviews that he had or any testimony that he would have related to those interviews that likely occurred over a year ago or more would not be relevant for today's proceedings, would not be relevant for what the court needs to determine as to what's in AW's best interests. It's simply not what the purpose of those interviews would have been. So he is not suitable for those types of determinations or that type of testimony. Those who would be individuals who are involved in determining what is in AW's best interest, such as her counselors, her treaters, even Ms. Moore, who's supervised visitations. Those people who have current relevant information to offer, those people may be able to offer information related to best interest. But if the interviews of AW by Detective Sergeant Dreyer were anytime prior to the last 6 months, because of her age and because of the development that she's going through, just in terms of growth and what she's learning at her age, most importantly, that type of testimony should not be considered at all by the court, because it's simply not relevant to today's situation, to today's factors, and to who AW is today, which is what the court needs to determine. So I don't believe that any possible testimony by Detective Sergeant Dreyer, in light of those issues, could be possibly relevant for these proceedings.
thank you, Mr. Head. I think that your objections sound more as it relates to the weight of the testimony that would be given by this particular witness rather than the admissibility of it. So I will allow the witness to take the stand for purposes as best articulated, frankly, by Attorney Ariel Berger. So Ms. Kuhn, if you could make sure that you limit your questioning to specific personal knowledge that the detective may have, and of course, anything that would be relevant under our best interest factors in 700-5101 subsection A. So you may retreat from the hallway if you wish.
Your Honor, I just like to lodge one more objection. We never received a copy of subpoena of any subpoena for Detective Sergeant Dreyer. So we would object to him appearing at all in these proceedings because we were not properly served under the court rules with any subpoena.
Thank you. The objection is overruled. There was no discovery issued in this case, nor any requirement to publish a witness list. And today was the date and time set for evidentiary hearing. I didn't receive any indication either, but today is the date and time set for the evidentiary hearing. And we're gonna hear from the witnesses that we need to hear from, but your witness or your objection is duly noted.
Your Honor, I'd like to note also that we did send out copies to all the parties in the mail, the
Thank
same
you.
copy that we filed.
Very good. Okay, where's your detective?
He is in the building, Your Honor. I just sent a message that we are ready for him, so I'm assuming he's waiting down the hall in an office.
While we're waiting for him, who else do you intend to call today? If I could have those names, please.
Your Honor, I plan to call Amber Million, my client.
Can you please come up here, sir?
Come on.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir.
Feel free to take a seat. Your full name, could you state it and spell it, please?
Yes, ma'am. Detective Daniel Drewer, DANIEL DREWYOR.
Thank you so much. Right as you came in, I was asking Ms. Kuhn, the rest of her witnesses, if you could just finish answering that question.
So, Your Honor, I'm calling the detective and I'm calling Amber Million.
Okay, any witnesses that you'll have today, Mr. Head?
Jaron Warner.
Anyone else?
Your Honor, I'll be calling Zachary Buck.
Okay,
No witnesses, Your Honor.
We may reserve the right to call additional family members, including Jaron's grandmother, Dale Warner's mother, Clara Warner.
I'm sorry, what was your name?
I'm sorry.
My name is Clara Mitchell.
Sorry, I apologize.
How do you spell it?
MICHALUK.
And your first name?
Clara, CLARA.
Thank you.
Yes, Your Honor. If any potential witnesses are not interested parties, I would just ask that they be sequestered.
Objections?
No objections.
No objection.
No objection.
All right, so that means that Ms. Million, well, she's our moving party, so I'm not sure she counts as a witness. Jaron Warner, Zach Bach, and Ms. Clara Mitchell.
Actually, Your Honor, I believe that Mr. Jaron Warner and Mr. Zachary Bach, because they are interested parties, and Mr. Jaron Warner has been considered to have filed a competing petition, that they should be permitted to remain in the courtroom.
Objections?
No
objections.
You object to Zachary Bach.
You objecting to sequestration?
Where I was objecting to him not being sequestered. Which is, I think, what Ms. Berger was just indicating.
So you don't object to Jaron Warner, but you do as it relates to Zach Bach?
Correct, because Jaron Warner is the current guardian and obviously these proceedings involve his suitability, so that he should definitely be present.
I'm sorry, maybe I missed it. Did you ask for the exception for Mr. Bach, Ms. Berger?
I did, Your Honor,
Okay, what was your reasoning?
that he is an interested party.
Argument on that point?
Any testimony that he may hear could taint his objective testimony by himself.
But you don't argue that he is not an interested party?
He is, Your Honor, I'm not sure that he is an interested party as a sibling under the statute. I'm not sure that he's listed as he should be an interested party. He's not a petitioner. He's a relative, but I don't think all siblings in all guardianship proceedings are interested persons under the statute.
Anyone else like to weigh in?
Your Honor, he is an interested party.
He is one of the ones that would be granted the visitation as well in this matter. It was ordered that the maternal siblings be granted visitation under this same matter.
Interested party is a term of art under EPIC, and I'm not sure the statute provides for all siblings to be interested parties in minor guardianship proceedings. I don't believe that he's defined as the siblings are defined as interested parties unless they are petitioners or respondents.
you agree he's an interested party, especially in light of the fact that the sibling visitation would concern him. So I think that really only sequesters Ms. Clara Mitchellok. So do you still wish to pursue sequestration? And ask her to step into the hallways, counselors?
Yes.
Okay, so Ms. Clara Mitchellok, if you could step into the hallway until it's time for you to testify, we appreciate your patience. Thank you. All right, thank you for your patience. Testimony, you may proceed.
Thank you, Your Honor. Good morning, Detective. How are you?
Morning, how are you today?
I'm well. Detective, you've already stated your full name for the record. Can you state where you are employed?
I'm a detective sergeant with the Michigan State Police.
And how long have you been employed with the Michigan State Police?
We're coming up on 10 years.
And what are your duties and responsibilities?
Currently, I'm assigned to the Special Investigation Section, which its primary function are major crimes against people and violent crime.
And how long have you been assigned to that unit?
I've been in SIS for about 2.5 years.
And what is your educational background?
I have an associate's degree in business management, and I've completed the Michigan State Police Training Academy.
And what other specialized training have you had in the investigation of serious crimes?
I've had training specifically for investigation of homicides, investigation of violent crimes, read, interview, and interrogation, forensic interviewing children, passive interviewing of witnesses and victims, and numerous other trainings as it relates to violent crime, crimes with weapons, forensic training, forensic response, collection of evidence.
Detective, approximately how many cases have you investigated during your career?
Hundreds, if not over 1,000.
Approximately how many children have you interviewed?
I would say there's a child involved in probably between 30 and 40% of the cases I work. So, 30 to 40% of that 1,000, so 300 to 400, I'd say.
Detective, how many times have you testified in court?
I couldn't tell you a lot, unfortunately. Kidding.
Detective, is there anyone else that you are aware of that has more knowledge in the Warner investigation than you?
Objection, speculation.
Any response?
I don't think it's speculation if he can answer that. He has knowledge of all of the people that are a part of this investigation. He would know whether or not he has the most knowledge of what's going on in the Warner investigation.
That wasn't the question, number one. And number two, there's no foundation that would have any type of knowledge as to any relationships that AW has.
I can build a foundation.
Go ahead. I'd like to know why we need to know that.
Why? Because
Yes.
I'm going to be asking him questions about what he has found out during the course of his investigation involving the Warner family. And I want to establish that it wasn't an investigation where he spent an hour talking to a family relative, but that he spent many, many hours on this case. I can reframe the question to ask him how long he's been working on the case, if that would be better.
Again, as to relevance, it doesn't go to the best interest standards. It doesn't go to the relationships that AW has with the current temporary guardian or the petitioner. Any testimony that you could offer on those points just simply are not relevant for these proceedings.
Thank you. I will allow you to rephrase.
Thank you. Detective, how many hours have you spent working on the Warner case?
I began as an assistant capacity of the Sheriff's Department in March of 22. I probably spent an average of 10 hours a week on the case in that capacity until August of that year, in which I assumed a full-time role. And I've been working on occasion, I've helped out with other cases, but 99% of my focus is on this specific case since last August. And I probably work an average of between 50 and 60 hours a week. And I'm terrible at math, so you wanna.
And in the course of your investigation, have you had any interaction with Dee Warner's adult children?
Yes,
And in the course of your investigation, have you had any contact with Dale Warner's adult children?
yes,
And are you aware of anyone else also having contact with either Dee Warner or Dale Warner's adult children during the course of this investigation?
am I aware of anyone else who has also had contact with them?
Correct.
Yes, and to be more specific, aside from the contact that I've had, much of the information that we have is from reviewing communications. So in other words, I may know things, to pick on Zach from, I may know things about Zach, not because he told me, but because I've reviewed communications. Does that make sense?
It does. So is there anyone else then that you're aware that has more knowledge in the Warner investigation than you?
No, ma'am.
Your Honor, I would move to qualify the detective as an expert in child forensic interviews and criminal investigations.
We would object. We have not heard his extent to training with respect to child forensic interviews. We have not had an opportunity to voir dire on that issue or hear any foundation on that issue in terms of what specialized training, the number of hours, or anything of that nature.
How is having him qualified as an expert helpful to me in determining the question as to who should be the guardian for the child today?
Based on his extensive knowledge and involvement with the Warner family, it would allow you or others to ask his opinion. So I think it could be very helpful if we qualify the detective as an expert in regard to asking him those opinions based on his extensive knowledge, his review of communications, as he stated, as well as his knowledge of this family
So you want me to qualify him as an expert in the area of criminal investigations and what else?
and child interview. Ms. Berger.
Yes, thank you, Judge. Pursuant to Court Rule 702, expert testimony by experts. If you're able to determine that any information that Detective Dreer could provide to this court based on his technical training or specialized knowledge in the case, if any of that information will assist the trier of fact in coming to a decision or in weighing the evidence, then I believe it is proper for him to be qualified as an expert. He did testify that he is not aware of anyone else that has any more knowledge in this case. And if Mr. Head would like, I can, or I'm sure Mr. Kuhn can, get more information on his specific training related to child interviews, how many he's done, and how many times he's testified to that fact.
Just for some clarification, the offer is that he be qualified as an expert for child interviewing and criminal investigations. That would not give him the ability to offer any opinion as to the suitability of Jaron Warner or of the petitioner, or make any determinations or opinions related to any of their character or anything else related to any relationships other than if the court were to qualify him as an expert related to the forensic interviewing process and investigative procedural processes. So I'm not sure how his testimony related to his interviewing techniques or the investigation, criminal investigation techniques could be helpful to this court. Any opinions related to that simply aren't relevant to these proceedings.
Your Honor, I'm going to object. Mr. Head keeps limiting this hearing to Jaron Warner's suitability. This hearing is also dealing with the best interest standards. So Mr. Head's references to suitability, if that's what he's basing his objection on, it's a misfounded objection because we're also talking about best interest. Part of the best interest standard deals with morality of individuals. And based on the detective's extensive knowledge of this family, he would and should be able to offer his opinion regarding the morality of parties. He should also be able to weigh in on the best interest factors. This is a very unique case when it comes to having a person that has spent thousands of hours on a case and has had extensive contact with both Dale Warner's adult children and Dee Warner's adult children.
He's not offered as an expert in morality. He's not offered as an expert in character. He's offered as an expert in investigative procedures and interviewing techniques of minor children. That would not give him the ability to opine and offer his opinion on all of the things that were just articulated by his sister counsel. He's not an expert in the best interest factors for children. He was never tasked with determining what those factors are, and that was not certainly a part of his criminal investigation. So none of his testimony would be relevant on those issues unless he's going to limit his testimony as to the investigative techniques and specifically the forensic interview of AW. That should be the extent of his testimony. He's not qualified as an expert. He's not even offered as an expert on morality or the character of any other individuals, interested or not.
Your Honor, yes, as a court.
Ms. Kuhn and Mr. Head, thank you for your arguments, but I've heard enough. Do you want to weigh in, Ms. Wilhelm? Any at all?
No, Your Honor, I
Thank
will
you.
not wait.
All right, I don't think his expertise in the area of criminal investigations or child interviewing would help me as I look at the best interest factors as regards to this particular minor. So I'm going to deny it because I don't see the relevance.
Okay.
I will say though, however, we are going to have to take a brief recess.